To help us with a little bit of analysis on Judge Mandela Makaula's recusal, we're now joined on the line by legal expert Ulrich Roux. Ulrich, thanks very much for joining us. Always a pleasure to talk to you. From your view, do you think that this was a prudent thing for the judge to do, to remove himself from this case?
Hi, good afternoon, Peter. Thank you for having me. Yes, the difficulty that the judge was faced with is that if he persisted with presiding over this matter and the matter was seen out to its finality, in other words, he either convicted the accused or acquitted him, there would have been a very strong likelihood that an application for the review of the matter could have been brought by either party, both because of his involvement during the cross-examination of the first witness, as well as this other involvement with his ownership pertaining to the guest house. So at the end of the day, it would not have been in his interest or in the interest of justice to persist with this matter, given that very likely risk that the matter would have been seen to its finality. All of the state witnesses and defense witnesses would have been called only for a review application to be brought at the end of the matter. So in instances like this, where there's allegations of the presiding officer either being biased or unobjective, it's always better to see the presiding officer recuse himself, at the beginning of the matter, rather than all the parties having to endure an entire trial, only for the trial at the end of the day to be regarded as being null and void.
All right, let's separate the issues, because he's quite adamant that on the first one, that is that he was biased towards Cheryl Zondi, the first witness. He said that wasn't the case, and in fact this went all the way to the Supreme Court, and I think it was now going to the Constitutional Court. So he's saying he's recusing himself only because his wife is the owner of this bed and breakfast. The question then, if that's the case, does that mean any case at all where a witness stays at this bed and breakfast, he's going to have to recuse himself?
Only where that allegation is made, and at the end of the day, once again, if any finger can be pointed to a presiding officer to say that, well, because of certain circumstances, your judgment was clouded, or because of the fact that a state witness was staying at a guest house that you own, you could have interacted with that witness outside of the courtroom. You could have been privy to certain information that you shouldn't have been to outside of the courtroom. And unfortunately, that would really be detrimental towards not only his reputation, but as I said, the case. So if ever an allegation like that is made, then it is, in my view, a better option to rather recuse yourself than to become embroiled in a situation where it is claimed that you acted in an unobjective manner. On the first point, whether he became, he was lenient towards the witness, we see that a lot. And I've been involved in many matters where magistrates or judges have recused themselves simply because of the fact that, as I said before, if you persist with a matter and there are these allegations that you did not behave appropriately during the trial, it could very well render the trial null and void at the end of the day. And then you have wasted everyone's time, and it would have been a futile exercise. So what is going to happen now is a new judge will be appointed, and the matter is going to be started afresh or anew, which means that the first state witness will have to testify once again.
All right, so you're saying that Cheryl Zondi is going to have to take to the witness stand all over again, and we start from day one, as it were?
Yes, the matter starts de novo, so that means afresh, and the state will have to lead that evidence again.
Wow, so none of the testimony that's come up, because it was quite an emotional and difficult testimony that she gave, none of what she said can be taken forward at all in any way, even though that a new judge will be presiding?
Unless the parties agree, and there's an explicit agreement between the parties and the judge that her testimony can stand and that it will be accepted by the judge, then that would have to be the case, unfortunately, for her. She did give testimony under oath, and it still remains under oath, but it will not form part of the record in front of the new judge unless an explicit agreement is agreed upon by the parties.
All right, Ulrich Roux, thanks very much indeed for sharing your insights with us. So it looks like this case is likely going to start again from scratch with a new judge, and Cheryl Zondi once again is going to have to give testimony facing Peter Daubermann once again.